Good afternoon again, everyone. Hello, and a very big welcome to our seminar on eligibility following Brexit. Who is in and who is out, and the options available to those who are homeless. I'm Marisa Cohen. I'm a barrister here at Doughty Street, practicing the public law, immigration and community care teams. Eligibility for accommodation is one of the most important areas that we work in, because of course no one can do anything without a roof over their head. It is also one of the most difficult areas of law that we come across, with a real need for consistent practices and joined-up thinking. We have three absolutely fantastic speakers tonight, who I'm delighted to introduce. Firstly, we have Simon Cox, whose specialist practice includes all aspects of immigration, nationality, and social security law, as well as migrants' eligibility to housing and community care, export and coordination of social security benefits, and hostile environment practices. Simon has acted in many leading cases for individuals, groups of victims, and NGOs at all levels, including before the ECJ and the ECHR, or the European Court of Human Rights. Recently, Simon has been involved in the Fatila-type discrimination challenge brought on behalf of 3 million effectively denied their votes in the 2019 election. Today, Simon will talk about eligibility under the Housing Act, Part 7, for EU citizens and their family members after 31st of December 2020. So, for example, the distinction between those with pre-settled status, or who were already resident before or on that date, and new arrivals. A very topical and much needed discussion. Next, we will have Donnchadh, who practices in the community care, education and inquest teams, with a particular focus on public and discrimination law challenges. Donnchadh has particular experience in advising migrants who face discrimination and are excluded from state support. He has recently been involved in linked claims considering the lawfulness of local authorities placing unaccompanied asylum-seeking children in NAS accommodation. Today, Donnchadh will speak about accommodation under paragraph 9 of Schedule 10 to the Immigration Act 2016, otherwise known as Schedule 10 accommodation, for those who are on immigration bail, a very wide category indeed. Finally, we have Westgate QC, who leads the public law and housing and social welfare teams in Chambers. It will not surprise anyone who has come across Martin to know that he has been described as a distinguished human rights practitioner and a widely renowned stock with a depth of experience in housing and social welfare work and its relation to community care, as well as being highly regarded for his handling of immigration and trafficking cases. Martin has been involved in several high-profile cases, and today he will speak about his pending judgment in the Brighton case, which is on the powers that local authorities have to provide shelter to those with no recourse to public funds, following the Everyone In initiative. This judgment is likely to have far-ranging effects on how local authorities deal with these powers in other scenarios. As usual, you will notice that your mics are muted and your videos are off. That is a pre-setting, so please don't be alarmed. It just stops any background interference. We are really looking forward to your questions and your comments today. If you have questions for the panel, can I ask you to please use the Q&A function on your screen to make sure that we see them. If you have comments that you want to share with everyone on the webinar, then please use the chat function. I will share your questions with the panel for them to answer after the webinar. We'll deal with as many as we can, and I may post them to the chat too. First come, first served, to get those questions in nice and early. We are recording this seminar, and a copy will be available on our website soon after we finish, for you or any colleagues who are unable to attend. Without further ado, it's over to Simon on eligibility post-Brexit.
Thank you very much, Marisa. Good afternoon, everybody. So the focus of what I'm going to talk about today is really the changes that happened on the 31st of December 2020 at 11 o'clock in the evening, and the shift to the new fully post-Brexit regime. And I'm going to focus on the new categories that now exist for homelessness eligibility, and in particular, focusing on EU citizens and their family members, how you can decide when you're advising an EU citizen or family member whether or not they're eligible. Next slide, please, Ray. So what happened on the 31st of December? Well, the Immigration and Social Security Coordination EU Withdrawal Act came into force, ending the right of free movement and revoking the 2016 Immigration European Economic Area regulations. But they didn't cease to have effect for everybody, as we shall see. They were preserved in force by the Citizens' Rights Application Deadline and Temporary Protection EU Exit Regulations 2020, and also by the commencement regulations for the 2020 Act itself. Could you, next slide, please, Ray. So the basic headlines are: free movement abolished, and with it, rights to reside. New EEA arrivals are going to be treated the same as non-EEA immigrants. So the general rule is going to be that everyone who isn't a British citizen, or as we'll see in a second, an Irish citizen, everyone who isn't British or Irish citizenship is an immigrant for the purposes of homelessness assistance, and the same set of rules apply to all those people. Now, that's a complicated set of rules, as we already know. Different treatment between people who are settled here, between people who have certain kinds of leave and people who don't have any leave. But the key takeaway here is that EU citizens now, as a rule, fall under that regime that's always applied to non-EU citizens. And what I want to do is to try to explain the border between those who continue to benefit from the old rules and those who fall under the new rules. The basic message is that people who are already resident here on the 31st of December will keep those rights, along with anyone who gets EU settled status or pre-settled status. And the other message is that, except for a few small details, which I don't plan to go into, the rules about which ones of those groups have eligibility, which ones of those groups have the right to reside, don't change. So the big change is taking away rights from new arriving EU citizens and family members, but leaving existing EU citizens and family members governed by a very similar regime to the one that existed on the 31st of December. Next slide, please. There is a big exception to the new rules, which is Irish citizens. So whereas legally speaking, under the rules that existed last year, Irish citizens would have to establish whether or not they had a right to reside, either under EU law or granted under UK law, for example, indefinite leave to remain. The government has now clarified with primary legislation that Irish citizens are not subject to immigration control. That means that they are treated for eligibility purposes in the same way that they would be if they were British citizens. The only exception to that is for a very small number of people, probably less than 10, who are Irish citizens subject to a deportation or exclusion order. But these new laws do not apply to the family members of Irish citizens, unless, of course, they are Irish citizens themselves. Next slide, please. So we can look at there being 5 groups, of whom I'm going to talk about 4 of these other EEA cases. So that's non-British, non-Irish citizens, people who have settled status, group 1, people who have the pre-settled status under the EU settlement scheme, people who don't have either of those, but were lawfully resident here on the last day of last year, frontier workers, who I'm not going to talk about, but we need to acknowledge they're there, and then everyone else. Next slide, please. So the first group, it's very simple. If your client has indefinite leave to remain granted under Appendix EU, if they have what is also called settled status, then they are eligible. And that's so whether or not it was granted in the UK or it was granted when they were abroad. Next slide, please. Now, pre-settled status does not count for eligibility. It's excluded under the regulations governing homelessness assistance and housing assistance. And so just as before the 31st of December, people with pre-settled status need to show another right to reside in order to be eligible. And There isn't time in this talk to go into the way that the EEA regs used to confer a right to reside, but those same mechanisms will apply from the 1st of January to people who have PSS. So they will need to demonstrate that they are, at the time that they say they're eligible, a worker or self-employed, or that they've retained worker or self-employed status, or that they're a family member of somebody who has that status, or that they've acquired a right of permanent residence under EU law. That is on top of them having pre-settled status. Now, it doesn't matter when pre-settled status was granted. It could be granted today. If it's granted today, what went on in the past is not relevant unless it tells us whether they also have an EU law right to reside today in order to establish that additional right to reside that they need to show to qualify for eligibility. Next, please. Now, there is a legal challenge underway to pre-settled status and that rule, but that challenge relates to the rule as it applied down to the 31st of December. That's in the case of Flotilla. It failed in the High Court. It succeeded in the Court of Appeal. And therefore, the law as it currently stands is that people is that pre-settled status was not excluded as a qualifying right to reside for eligibility down to the 31st of December of last year. Now, the distinction is because the Flotilla judgment was based upon EU law, and in particular, the prohibition on discrimination in Article 18 of the EU Treaty. And EU law doesn't apply in the UK anymore from the 31st of December. So the courts haven't looked at yet whether or not that same logic would apply to the EU-UK withdrawal agreement, right to equal treatment, under Article 23. But there are PAPs being sent in reliance upon that provision. And I think it's likely that, certainly hopeful, that the court will be seized to some challenges quite soon, in which applicants will be saying, well, the legal basis for equality has changed, but the application of that basis hasn't changed. So the Flotilla argument, the logic of the Flotilla argument applies to cases arising after the 1st of January. Now, the DWP are appealing Flotilla to the Supreme Court, and so they may well resist the application of that, seek to have these cases stayed, but it may also be that people will secure interim relief on the basis of a binding Court of Appeal judgment, at least binding as far as the law was concerned, the old law, so long as they can persuade the court that they have a sufficiently convincing argument under the new law. And obviously, Flotilla only concerns really entitlement for 18 months, down to the 31st of December, whereas we will have people with PSS for at least the next 5 years, and probably, given that some people will then apply for extensions, and those will take time to decide, for the next 6, maybe 7 years. So the PSS issue post-EU law is a much bigger issue in terms of public expenditure and in terms of claimants' rights than the pure Flotilla issue was. Next, please. So that's people with PSS. What about people who haven't got any EU status? Well, the law until the 30th of June of this year is that people who are lawfully resident under the EEA regs on the last day of last year are subject to essentially the same rules as people with PSS. So they also need to show that they have this underlying additional right to reside under the EEA regs still. But in order to get into that group, they also need to show that they had it on the 31st of December. Now, that's the law until the 30th of June. After the 30th of June, that will only continue for individuals who had made an in-time application for EUSS status before the 30th of June or on the 30th of June. So again, this class of people may still be quite large. There'll be people who are who haven't got around to it for various reasons. There'll be people who are subject to enforcement action by the Home Office who are challenging that enforcement action. Those cases may take some time. So these rules are still likely to go on applying well into the back half of this year and into 2022. Next, please. So who counts as resident under that second set of rules that I'm talking about? Not PSS. If you've got PSS, you don't need to worry about what your status was on the 31st of December. But if you haven't got it yet, or you've been refused it and you're appealing, then you need to show, first of all, that you were resident in the UK on that day. Now, my view, and I haven't seen this tested in the courts yet, is that presence is neither necessary nor sufficient. In other words, you don't have to have been present on the 31st of December to have been a resident, but if you were, it doesn't necessarily mean that you were lawfully resident. Next slide. So residence includes absence of periods that don't break continuity of residence under the EEA regs, up to 6 months in any year, and up to 12 months once for an important reason. So that means that you may have clients coming here in May, who were here in November, haven't been away for more than 6 months, and fall homeless. And the question arises whether or not they count under this rule. Well, the question isn't going to be determined by their presence on the 31st of December. Next slide. And it goes further back than that because there are two classes of people who had the right of permanent residence and people who actually, but hadn't lost it, and people who actually did lose the right to permanent residence, but weren't continuously absent for 5 years. So we may even have clients coming here who've been away from the UK continuously for almost 5 years and who are coming back and then falling into the need for housing assistance. And they may qualify. So the cutoff date really for your clients is, have you been away for more than 5 years? If you've been away for less than 5 years, then we need to get into what their residence status was when they left to see if they had permanent residence. If they didn't, then the next question is, have they been absent for more than 6 months or more than a year in special circumstances? Next, please. So who counts as lawfully resident here on the 31st of December? Well, obviously anybody who had right of permanent residence is lawfully resident. Another group of people who are maybe relatively easy to shoe in are people who had arrived in the 3 months before the 31st of December, so arrived from the 1st of October 2020, because that group of people have the right to reside in the UK under Article 6 of the 2016 regulations, that first initial period. So if you can prove that they first arrived in the UK in the last 3 months of 2020, they may actually have a simpler case than someone who's been here for 2 or 3 years, who will need to show that on the 31st of December, they were still working, self-employed, retaining that right, family member of someone in that situation, family member of someone who's got permanent residence, and so on. But there's one extra group of people who might possibly have arguments, and that's people who don't have a right to reside under the EEA regs, which covers almost all the rights to reside, but do have a right to reside outside the EEA regs. And I mentioned them there. So SAM-PRE cases, that's women who stop work because of pregnancy or childbirth. And carpenter cases, people who are family members of British citizens resident in the UK who had business or work, the British citizen had business or work elsewhere in the EU. I mean, I think in these cases, as in lots of these other cases, you're going to be looking around for someone who's specialising in EU immigration law to refer to try to get those points. But what I'm trying to pick up here is to make sure that people don't assume that these edgy cases don't have rights to reside and therefore eligibility. Next, please. So last point on who has residence. What happens if somebody turns up here at 10 o'clock on the night of the 31st of December? Does it mean more than presence? In my view, it doesn't, for the reasons that I suggest there. What matters is the exercise of the right to reside, and the exercise of the right to reside begins when the person sets foot on the soil of the UK, or perhaps when the aeroplane touches down. And so there will be last minute cases where I think the arguments can be run. Next slide, please, Ray. Now, as I've mentioned, this protection expires on the 30th of June for people who haven't applied. They have to apply in their own right. It has to be a valid application. So expect local authorities and other people assessing these cases to be contacting the Home Office to see whether they've logged an application. And of course, there may be issues about what is a valid application. The rules are pretty tight, but there may be arguments that they need to be looser once they're construed in accordance with the withdrawal agreement. Next slide. skipped out group 4. They're frontier workers, and I'm not in a position to talk about them, but it's unlikely that they're going to be wanting eligibility, given that they need to be living abroad and only working here. So a frontier worker, it's not someone who is trying to drive indigenous people out of the west of the United States. It's someone who regularly crosses the frontier between the United Kingdom and another EU country. Ireland, France, most obvious. People working on the Channel Tunnel, lorry drivers, they fall into that category. The last group of people, everybody else, complication. If I come through the gates, the e-gates, once, and I don't have to spend, whether or not I have to spend time in my hotel in quarantine, and I'm coming on a French passport, it's probably going to register me as coming in with deemed leave to enter for 6 months with a condition of no recourse to public funds. Even if I was here in November, and even if I've been living here for a long time, if I haven't already got PSS or EUSS. Next slide, please. Now, the grant of leave to remain doesn't affect the situation of somebody who's exempt from immigration control under Section 7 of the Immigration Act 1988, and that section is continued in force by the commencement order in relation to people who were legally residing in the UK on the last day of last year. So you may have clients where the local authority is checking with the Home Office and they're saying, well, they've got 6 months leave to enter, they're just a visitor. And that person's saying, yeah, I've been living here for years. I went to see my mum in Germany and I came back in March. And yeah, I haven't got around to doing my EUSS application, but I'm going to do it soon, honest. So in those cases, there is an argument that those people are eligible, or at least that the same rules that would apply to them if they'd never left apply to test eligibility. Again, did they have a right to reside here on the 30th of December? And have they currently got that right to reside? Or at least are they someone who falls under the rules for a right to reside as a worker, self-employed, and so on? Next slide, Ray. That's the end of what I wanted to cover today. Happy to try and deal with questions. I haven't had the chance in the brief presentation to cover all those complicated rules about eligibility, but what I've tried to do is to introduce you to the new complicated rules about which set of eligibility rules apply to somebody. And the basic message, remember, is if you can't bring somebody in under any of those rules, if they don't have a stamp of settled status or pre-settled status, if they weren't resident here on the 30th of December, if they're not the family member of somebody resident here on the 30th of December, then they're going to fall under the old-fashioned eligibility rules that apply to Americans and Indians and Brazilians, which, as we know, are very restrictive and will generally mean that people are only eligible if they have indefinite leave to remain or leave to remain without a public funds condition attached. Thank you. Back to you, Marisa, or on to you, Donna.
I'm just going to start talking now. I'm Donnchadh. As Marisa already introduced, I mainly practice in community care, in particular as it relates to migrants and migrant support. I also do a bit of housing in terms of my antisocial behaviour injunction work. So I'm wearing 2 hats in that sense today. Next slide, please, Ray. So I'm going to be talking about Schedule 10 accommodation, which is effectively provided for in paragraph 9 of Schedule 10 of the Immigration Act 2016, which provides that the Secretary of State may provide or arrange for the provision of facilities for the accommodation of that person at address. Effectively, it's a way of the Secretary of State providing accommodation for those who are in immigration bail, which is now much more widely expanded since the introduction of Schedule 10, which converted those who were previously on temporary admission on effectively to bail. So what used to be different regimes, now everyone's on bail unless you're at large. So this accommodation is becoming increasingly important because it's fulfilling the role of a stopgap for those who need accommodation, those who are destitute and in need of accommodation. This accommodation is only available where the individual is on immigration bail. They're subject to a residence condition, so you must reside at a particular address, and they're unable to support themselves without Secretary of State's assistance. And the final and most important criteria is that there are exceptional circumstances that justify the use of this power. Next slide, please. Thank you. So as I said, this is now much wider and much more important in the sense of those who are on bail as a much broader category. In the recent case of Katie, it was estimated that those on bail might be up to 90,000 people. So bail from immigration detention, or just on bail as the term is used. It's for those who fall outside the definition of asylum seeker or failed asylum seekers who can't have access to Section 4 accommodation of the Immigration and Asylum Act 1999 or Section 95 accommodation. And so it often will be non-detained foreign national offenders, detained foreign national offenders, or basically anyone else that doesn't fall within the broad categories. It's not going to be available for those who are who have dependents. For those who have dependents, they should seek the support under Section 17 of the Children Act 1989. That's the most that's the way that they're going to obtain that support. There's no provision for support under Schedule 10 in that way. Next slide, please, Ray. Thank you. So this is the broad category of the people that the Secretary of State believes exceptional circumstances justify the granting of this support and this accommodation. So it's cases where they've been given bail under the Special Immigration Asylum Commission, or cases, high harm cases, so those foreign national offenders who pose a particular risk to the public, or on the basis of different assessments on what the risk they pose to individuals. And Article 3, the European Convention on Human Rights cases. And basically, again, anyone else in which the Secretary of State considers other exceptional circumstances. And I'll touch a bit more on what that is. The point of this is, though, that they must be able to show that they cannot reasonably be expected to leave the United Kingdom. So there has to be some sort of genuine obstacle that they cannot be expected to be resolved. So for instance, physical or mental impairment, or there's some reason that they're making steps to leave, but it's not possible at the time, as I'm sure we'll see with lots of clients in relation to COVID. There's lots of people that will fall within this point. For instance, people who have outstanding Article 8 applications or statelessness applications. But those who make this kind of applications should be careful to keep in line with their immigration advisor to understand what impact this may or may not have on any sort of application that's outstanding. Indeed, those who maybe had refugee status, left the country, came back, and their refugee status had expired. It's this kind of stopgap provision that's meant to be providing for. So next slide, please, Ray. So what effectively brought into effect this other exceptional circumstances cases is the case, Marisa's case, which she acted for one of the claimants in conjoined judicial review claims, Hammersmith. In which it was held that previously the Secretary of State was limiting Schedule 10 accommodation to 3 distinct categories of SAT cases, high harm cases, and Article 3 breaches. And so it meant that individuals, I'm not sure if Marisa's client was one of these individuals, but those who perhaps weren't high harm cases, but were facing destitution, weren't able to make their representations known, and that they were in need of accommodation. And it was a fetter of the Secretary of State's discretion. And so what we've now got is interim guidance that expressly states that exceptional circumstances are not limited to these categories. And so there's clear instruction that they have to consider whether there is any other exceptional circumstances in the case that might warrant this granting of Schedule 10 accommodation. And it must be assessed in their own right about whether they do that explicitly, in spite of the fact that they do not fall within those 3 categories. Next slide, please, Ray. And so turning into what will make up most of those who don't fall into that, but also importantly, the Article 3 cases, it doesn't refer to any statutory destitution test as we see it in other sections, such as Section 95. And the question effectively will be, will the individual be destitute if they're not provided with accommodation and other assistance to meet their needs? And this will be where treatment arises to the level of Article 3 mistreatment. And so next slide, please, Ray. So this is a very brief summary of different points which may give rise to Article 3 breaches. I'm not going to go through each of them, but I'll just leave them up for a brief second so you can kind of consider the different points. And one of the really important points is about the degradation, which I think is often missed when we're talking about these claims, that it's important to highlight the kind of humiliation that exists for those who maybe have been going in between support and facing further destitution and further difficulties. And next slide, please, Ray. And so how to apply will effectively depend on what circumstances the individual's in. If you're in detention or your client is in detention, they can apply for this accommodation through the bail application that they make to be released from detention. So that'll be cases such as SAC or foreign national offenders who've been detained following this end of their sentence. However, if not, and even if the individual foreign national offender or SIAC case wanted to, a bail 409 form has now been introduced or has been amended in order to allow individuals to make this application. So this application is effectively the same as the ASF1 form. So that's the same form that's used to apply for Section 4 and Section 95 support. And so it's the same length, it addresses the same points, and you just need to inform the decision maker of the exceptional circumstances. Ordinarily, the Home Office policy says that it'll make a decision within 5 days, but it'll make the decision within 2 days if the decision is urgent. So that includes people who are street homeless already. People, unusually it says that people who have children under the age of 18, which are dependents, so I don't fully understand that. People with disabilities, elderly people, pregnant women, and other vulnerable groups will be able to have the urgent application process apply to them. The other point to highlight is that there's no appeal. The first tier tribunal, social entitlement chamber, the AST, doesn't have any jurisdiction to consider it. It's not listed in Section 103 as an option, and it's this difficulty that's created by Schedule 10 in the sense that the legislature or the legislative provisions haven't quite caught up with the fact that this is an accommodation to be used and to be utilised by those who are in need of that support. So the only option is judicial review. I did some considering a lot about whether legally it was in scope for this or not. It ultimately really depends on the circumstances. If your client is in detention, you can argue that falls within the legal aid scope, and also if it's part of their bail conditions, then it is. But whether it in of itself in the same way that Section 4 and Section 95 is, I don't think so. It's not in the same way. It may be possible under legal help, but again, without a public law decision, it's not exactly clear whether it does or doesn't. And it's this point about the legal aid or the legal provisions not having caught up with Schedule 10 accommodation. And then the next slide, please, Ray. So yeah, the main documents to go to is the immigration bail interim guidance, which is your first port of call in terms of those who are in need of support, and whether they apply and whether they meet the criteria and how they may or may not meet the criteria. And then the general immigration bail policy, in which you may need to consider whether your client is or is not on bail or has been served with a bail 201 notice about the fact that they're on bail. That was a very whistle-stop tour of Schedule 10 accommodation, but I'm just trying to encourage people to use it more and more because it is there for people to be used and to include those who have previously been excluded. Thank you.
Thank you very much, Donnchadh. Over to you now, Martin. Martin, I think you're on mute.
Thank you. Can you hear me now?
Yes, that's great. Thank you.
Good. Thank you. Yes, my name is Martin Westgate. I'm going to be talking about a specific aspect of this, which tries to focus on the issue as a public health issue rather than as a housing issue. And the reason I do that is really because of the a light that's been shone on this by the response to the COVID pandemic, and in particular the Everyone In initiative. I've got to say that everything I say on this has got to come with a bit of a health warning, in that what I'm doing really is running through some of the arguments that were canvassed in a case just before Christmas called TN and Brighton and Hove City Council. And judgments are weighted in that. So anything I say is liable to be falsified when judgment comes out. But subject to that, I'm going to run through some of the arguments that seem to be available. And really, if one is looking at this from a public health perspective, it's helpful to reflect really on just what an issue that is for the homeless population, particularly those rough sleeping. We get used to these shocking statistics and figures coming out, but the average age of death for someone who is rough sleeping, if you're a man, is 47 years old, and 43 years old if you're a woman. And if you're rough sleeping, then if you're a 56-year-old, then you're likely to have the level of frailty of an 89-year-old in the general population. So there are acute health issues that arise, and particularly the impact on those with no recourse to public funds. During the COVID pandemic, over half of that group who sought assistance, who suffered COVID symptoms, became either seriously ill or died. So it's something which has profound health impacts, and it's against that background that at the beginning of this year, the minister wrote a letter to all local authorities on what became the everyone in policy, urging them to offer accommodation to all rough sleepers by the end of that week. And by and large, they did. It was a pretty astonishing, successful programme, which shows what can be done with funding and will. And something like 15,000 people were offered shelter. That's 90% of rough sleepers. A high proportion of them were no recourse cases, about a quarter of them in London. And according to an article in The Lancet towards the end of last year, they estimated that it saved something like 266 lives and 338 ICU admissions in the first wave. We don't have the statistics for the second wave. But it raised an issue that we see it in the next slide, because only a couple of months later, in May 2020, the minister wrote another letter saying that the law regarding no recourse to public funds remains in place. And they said, perhaps rather cryptically, that local authorities have to use their judgment in assessing what support they give, and that they're used to exercising judgments like that, for example, during extreme weather where there's a risk to life. What the letter didn't do, unhelpfully, was identify what the powers were that local authorities had. And that then did lead to some authorities later, or in the course of this, taking the view that they didn't actually have any powers at all to provide accommodation for no recourse cases, because as you're aware, they're excluded from most routine or most normal housing powers, both allocation and homelessness. And there are some specific powers that are subject to limitations under Schedule 3 of the 2002 Act. But those aside, local authorities were saying, well, or some local authorities were saying, well, what powers do they have? And what I really want to do is focus really on what the powers might be. And the obvious place, next slide please, is Section 1 of the Localism Act, which, as you probably know, begins saying that a local authority has power to do anything that individuals generally may do. Well, individuals can provide accommodation, or they can pay for people to get accommodation, and therefore that ought to cover the issue. But the problem is that they can't do that if they're subject to a pre-commencement limitation, which is defined, as I've set out there, that it's a prohibition, restriction, or other limitation expressly imposed by a statutory provision. Now, it's an awkward concept to apply. It applied to this Act, and it applied to the 2002 Local Government Act before this, because nobody knew those acts were coming, and so earlier acts aren't going to mention the Localism Act unless they're explicitly amended, and none of them have been. And also, acts don't normally get framed in terms of a general prohibition. What normally happens is an act says you can do this, but not in these cases. And so it doesn't say that you can't absolutely provide housing or something like that. And so that creates a bit of a difficulty when one comes to, next slide please, the exclusion in the Section 185 of the Housing Act, which is framed in terms of someone not being eligible for housing assistance. But when you look at the reference to housing assistance in that section, it goes back to section 103, and it's under the functions under the following parts of that act. So it appears just to refer to homelessness provisions, but that's not what the High Court has decided. If you go to the next slide, please. In AR and Hammersmith, Upper Tribunal Judge Marcus decided that section 185, in fact, imposes a prohibition on the provision of accommodation under any enactment, and not just under the Housing Act. So what in effect it's saying is that it operates as a pre-enactment prohibition, and the effect of that is that you don't even get to the Localism Act, you don't even get to asking whether somebody is likely to suffer a breach of convention rights if they don't get provided with some help under the Localism Act, because you never get there, because section 185 closes it off. And that, if it's right, produces a very surprising result, because what it means is that local authorities are powerless, unless they can point to some other provision, to do anything, even in a case of someone who's going to suffer a breach of their convention rights, for example, because they're suffering extreme delay before they can apply for Section 4 accommodations of failed asylum seeker, or they're waiting for ages before the Secretary of State lifts their no recourse to public funds limitation. And but that seems to be the effect of what was said in AR. I mean, AR was a hard case, excuse me. It was I think a Lithuanian national who had been rejected, who wasn't here exercising any EU rights, and was trying in effect to use the Localism Act to get what he couldn't get under the Housing Act or under the Care Act. And so it's perhaps unsurprising that he lost the case on the facts, but it does have those rather extreme consequences. So possible ways around it, next slide please, are first of all, the limitation on section 185 only applies to a local housing authority. So if you can apply to an authority in some other capacity, then you might be able to say, well, they can apply and they can use the Localism Act. And that's significant, particularly in this kind of context, because certainly in the everyone in measures, it wasn't just housing authorities that were providing emergency accommodation. Other, what are described as first tier authorities, like the GLA, provided accommodation, even though they don't have any statutory powers to do so. But they're also not local housing authorities, so they're not caught by section 185. There's also a more convoluted line of reasoning, which I'm not going to go into in any detail, which is to say that it ought to have followed an earlier decision of the Court of Appeal called W and Lambeth, which basically would say that section 185 isn't a prohibition on providing accommodation. It simply defines the limits of what you can get under Part 7. And that's a sort of separate line of reasoning, which would take it outside the limitations in Section 1 of the 2011 Act. The third way around it is to say, well, actually what you're asking for here isn't the same thing that you get under, as I said here, Part 3 of the Housing, but Part 7 of the Housing Act. So what you're not being excluded from is homelessness provision. What you're asking for is something different from that. It's temporary shelter. And then the fourth way around is to say, well, it's got to be subject to Human Rights Act reading. And if what you do would produce a breach of the Human Rights Act, then that might, then an authority can't be excluded from doing it. So all of those points we'll have to see what the court makes of those points, but they're all ways that you can potentially argue around the application of AR. And then if I can just round up by dealing with some more general powers that are probably available in these circumstances. If you go to the next slide, please. There's the Housing Act 1980, section 180. That's not something which is limited by section 185 because it's not part of Part 7. that's excluded by it. And what it appears to do is to allow the authority to do, in effect, by the back door, what it can't do directly. So a local authority can provide a grant or loan to voluntary organisations, and there's no reason why that shouldn't include them being able to provide direct assistance with accommodation. And in fact, that would tie in with what local authorities have to think about when formulating their homelessness strategies, because that talks about activities and specific action that voluntary organisations might carry out. And in fact, it does seem clear that with the COVID response, many authorities were doing just that. They were working with organisations like St Mungo's and providing funds to them. And it may well be that that will be the exercise of the powers under Section 180. But then there are two little used up to now, but perhaps more directly applicable provisions. So we can go to the next slide for the first of those. That's the Local Government Act 1972, Section 138, which is a specific power that deals with emergencies or disasters which involve potentially a risk to life or a danger to life that's likely to affect the whole of an area or some of the inhabitants of an area. And on that basis, the authority can then, if it's satisfied that's there, incur expenditure to avert, alleviate or eradicate the effects of that event. And it's hard to see why that couldn't, or at least doesn't apply to the COVID pandemic. If it does apply, it triggers what on the face of it are very wide powers indeed. It's clearly apt to cover things like a flood or a seasonal emergency, perhaps, like extreme weather. And if it can cover those, then it's hard to see why it shouldn't cover something like the pandemic. And it's, if it applies, then it allows the authority to do anything, absolutely anything, that can alleviate or eradicate. And really the only contrary arguments can be that the authority doesn't think it's an emergency. Well, it's difficult for that to run in present circumstances. Or they say that Section 185 and the interpretation in AR excludes this power as well as any other power. But that, I think, is a fairly extravagant reading of Section 185 to cut down a provision like this. And then the last one I want to look at is, next slide, please, the National Health Service Act, which again, this is Section 2B, imposes broad duties on a local authority to take steps as it considers appropriate for improving the health of the people in its area. And that can include preventing risks or minimizing risks arising from accommodation or environment, or making available services of any person or any facilities. And so again, it's exceptionally broad. There's virtually no authority on this, but the only authority there is on a similar provision applying to the Secretary of State under 2A, and that stresses how broad this power is. And the advantage of it is that if you can bring yourself within this power, then it also opens up access to ring-fenced funding, which is available for this. And that's set out in a circular, the reference I give you there. And again, it's helpful there that it talks about this being available for seasonal death reduction initiatives. And that, of course, ought to be something that could cover things like winter shelter. And if it can cover that, then why can't it cover emergency accommodation for particular cases, particularly something like the COVID pandemic, but equally, it would be apt to cover individual cases going forward, not necessarily linked to something like the COVID pandemic. And again, the responses to this are really, tend to be those, well, this is something which is to do with the sort of health measures that you expect local authorities to carry out, like child health and that sort of thing. There are some provisions for preventing addiction and things of that kind. It's extremely wide, and there's no reason why it shouldn't cover some forms of accommodation at least. And I can see that it can't be used directly to replace provisions that you get under the Housing Act, but there's no reason why you can't supplement them in exceptional cases. So what's arisen out of the pandemic is a forced focus and concentration on these provisions, which certainly are potentially apt to cover the pandemic, but may well have much wider applications after that. So I'll stop there.
Thank you very much indeed, everybody. We've got some fantastic questions for our panel. So first question is for Simon, and that is whether you have a view on whether a flotilla type argument could be used in Part 7 of the Housing Act for non-eligible decisions when they have pre-settled status. And then linked to that, whether that would be via the Section 202 review or a Section 204 appeal, or indeed a separate judicial review entirely. Over to you, Simon.
Thank you. So I think all of those are available options. There is a good argument that if Article 23 of the withdrawal agreement prohibits this restriction as discriminatory, then it has direct effect in UK law through Section 7, capital A of the EU Withdrawal Act 2018. So that section was inserted by the Withdrawal Agreement Act of 2020, and effectively uses the same mechanism that we used to have for EU law to apply directly effective provisions of the withdrawal agreement into the UK legal order. So the argument would be that the exclusion of people with PSS as a form of eligibility being done by a mere regulation is overridden by the effect of the prohibition in discrimination in the Withdrawal Act, in the same way that EU law overrode it in Flotilla. So that means that you can raise it in your applications for assistance. You can raise it in challenges to refusals of assistance under the statutory scheme. But also claimants can, if they want to, I think, bring a separate parallel judicial review or a subsequent judicial review in which they argue to strike down those regulations. And I think the reason why that would be attractive to the court is that it would allow for the defendant to be the DWP, the SSHLG, I'm sorry, I'm missing an initial there, but for local government, Secretary of State for Housing and Local Government, Communities, Housing and Local Government, and the Home Office, who made the commencement order that continued the effect of these regulations. Whereas if you're only bringing a statutory appeal to the county court, it gets a bit messy in terms of having those actors come in, and they're the real target for it. It's not the local authority who made the regulations. They didn't, it's the Secretary of State. So in the cases where I'm looking at, then we're looking at using in parallel the methods to keep the person's a roof over their head or get a roof over their head, and to bring judicial review of the regulations.
That's interesting. Thank you, Simon. Martin, do you have a view on the procedure? Just to clarify the question with on the sort of flotilla type argument and using it in a Part 7 non-eligibility decision, and whether you would put that in at the application stage on Section 202 review and then on Section 204 appeal, or indeed whether you bring a separate judicial review.
I mean, I can see the virtue in bringing a separate judicial review for to get the appropriate parties before the court, but then I mean they can always they can always be invited to intervene or to be joined, but I mean I'd probably judicial review rather than appeal, but
okay. All right, thank you. And then we have a question for Donnchadh, which is for refugees who are detained under immigration powers pending a deportation decision, so presumably before there's been a decision on refugee status. The person says that the Secretary of State normally actually refuse a scheduled turn on the basis that they are not destitute, and they then signpost them to a local authority for housing support. Do you think that approach is correct, Donnchadh?
The other place where I spend a lot of my time, well, in my room, is the immigration bail tribunal, getting people who are subject to detention bail. And this is the kind of classic point where they need an address and they can't get address and they can't get proof of destitution because they're in detention at the time. My view would be that if they're due to be granted bail or they're granted bail at the tribunal and it's subject to the condition of an accommodation being provided, and that accommodation is Schedule 10, or well, in this case, they're saying that it's not destitute, and if they're not released, that they would be destitute, or if they're released, they would be destitute, then it should be that they're provided with Schedule 10 accommodation because they would be destitute. And if there's obstacles to removal, then they fit all the other criteria because they'd be on bail. And so that probably isn't the right approach, I would say. The difficulty is proving destitution if you're not actually destitute, but as we know from Limbuela, from the recent consideration in Hemninsky and W, they all reiterate that it's an imminent breach is also sufficient, and the Secretary of State has to take proactive steps to avoid destitution. The difficulty is no immigration bail tribunal or immigration tribunal is going to release an individual out into the open without an address. And so whether that'll ever arise is quite difficult, but I would say you have to make strong arguments about the destitution. I briefly discussed this with Simon as well. I think he wanted to make a point on this as well.
I mean, I have dealt with some of those cases where the Home Office say, well, you can get universal credit and you can go to the housing authority. And it seems to me that's a weak argument on the Home Office's side, because you simply can't get universal credit when you're on the day that you walk out of immigration detention. The DWP directions allow for advance awards of universal credit in the case of prisoners, precisely to get over this problem of prisoners being eligible for support as soon as they walk out the door. But those directions don't currently apply to people who are detained under immigration powers. So I think it's another facet of what Marisa and Donna have been challenging, which is that the Home Office have this pretext of having a support system that they're very reluctant to use, and instead they go on detaining people. So I do think that, I mean, in these cases, we've had to threaten judicial review of their failure to organise Schedule 10 accommodation, saying, if you give me Schedule 10 accommodation, and this was an EU national, then I'll go out into it and I'll claim a universal credit. And, you know, once I get my universal credit, then you can withdraw the support from me. You have to bridge me. I think that's where the argument goes.
I also just noticed you highlighted the point about it being recognised refugees. Effectively, it's anyone who's subject to deportation order. As far as I know, it doesn't really matter under what status they have. If they fall within that point, and it's to me, it seems like Schedule 10 accommodation would still apply. I don't know if you take a different view, Simon. If should be applying under Section 95, then
I think Schedule 10 accommodation. I mean, it's a residual power, and so it's not expressed to be limited by where Section 95 or Section 4 accommodation is available. I think the reason it is so limited is because the availability of that means that you're not destitute for the purposes of Schedule 10. So I think if the person was still an asylum seeker, then they should be applying for Section 95 support. Or if they're a failed asylum seeker, they should be applied for Section 4. But if, as I think the questioner suggests, they're a recognised refugee, but who's nevertheless someone who they're going to try and deport, then I think in that situation, you're probably Schedule 10, because I don't think you're a failed asylum seeker and you're not an asylum seeker.
Yeah.
So would it be worth then, in practical terms, say on that application for bail that Donnchadh mentioned, to actually put in evidence at that stage of destitution?
I mean, it is. I think it certainly is worth it. I think the challenge that we face is that the immigration judges don't have power to order the provision of Schedule 10 accommodation. They can just decide whether or not to release somebody. But I think it's really helpful to get a bail order that says, I would release this person if they had Schedule 10 accommodation. And then that puts you in the place to going to the High Court and saying they're acting illegally and not giving me Schedule 10 accommodation. And that's actually constituting an unlawful detention as well, which is what we've been doing.
Okay, interesting. A question for Martin. Would you be prepared to say where you think the court is likely to go, or what sort of focus the court might take in your Brighton case?
It's difficult. I mean, judgment is ought to be imminent. I mean, I was at some points concerned that we'd have a draft judgment when we were doing this talk, so I wouldn't be able to say anything at all about it. But it's the court doesn't have to make a decision on the Localism Act point, and so may not make a decision on that. I think it's quite difficult to say that the Local Government Act powers don't apply at all, and the same applies to the National Health Service powers. The Section 180 point was less in issue in that case. I'm not going to tempt fate, I think, by saying which way it's going to go. One point that wasn't really raised there in that case, again because of the facts, was that another potential argument that might arise would be that in a Care Act case, you may be able to say that the risks arising from COVID create a sort of destitution plus type.
That's interesting.
But because of the facts, that wasn't run. And the difficulty with that type of argument, as well as the Localism Act argument, is that both those powers are subject to Schedule 3 of the 2002 Act, and so you've got to show convention breach. And of course, it doesn't have to be the individual's convention breach. The advantage of being able to get in under the Local Government Act and National Health Service Act is that they're not caught by Schedule 3. So it's a general power, but.
Okay, thank you. It does sound like you might have a bit of a steer from the court on some of the powers, which will be very useful indeed. Okay, can I say thank you so much to our speakers tonight, or today rather, who have been absolutely fantastic. We've managed to add some much needed clarity to this area of law and of course their insight. And thank you also to all of our participants for joining this event. And that brings this seminar to a close, save that I do want to mention that there will be a brand new book titled Migrant Support Handbook, which will be published by Legal Action Group later this year. And it is co-authored by Shushan Liu at Doughty Street and by Connor Johnson at Garden Court Chambers. And there will be a formal launch and a seminar later on in the year in relation to that book, which sounds very exciting indeed. So please do watch out for that. That brings us to the end of this seminar. Thank you again, everyone.